Sorry, I gave the rest of you guys a chance. Yes, section 352.
Wait, you said no ladle too.
Well, I mean, nobody else raised their hand.
Well, but you said no ladle too.
But she was the first of all the ladle twos to raise her hand. Wow, really?
All right.
Gosh. Evenally, when there were anyone else besides ladle two. Okay, number 2. Second Starbucks card goes to whoever can tell me, más o menos, the language of the second sentence of 366.22. The language of the second sentence of 366.22. Anybody? More or less. You don't need to get it 100%.
The burden's on the department.
Okay, no. But you might want to hold on to that answer.
Maybe if nobody else has something.
And also, it was about raise your hand, and then you give the answer? No? Really? Okay. The court shall...
Return the child. The court shall return
No,
the child.
Ms. Taylor is speaking right now.
The court shall place the child with the parent, and unless there's a finding of the risk of emotional harm.
What kind of risk?
Emotional, physical, substantial risk of harm. Emotional, you know where it is.
By what? By what? By
Preponderance of the evidence.
exactly. And it dragged on you a little bit.
You know the problem is getting worked up.
All right, now number 3 for our last Starbucks card. What is the third sentence? So just to lead you into this, the second sentence of 366.22 more or less is, the court, after looking at all the admissible and relevant evidence, the court shall return the child home to the parent unless there is a showing of substantial risk of physical, emotional, blah, blah, blah harm.
Or reasonable service.
Now, what is the third sentence? Amy. Well, now you're not reading that, are you?
No, you're disqualified.
Say that again? The social worker has the burden of proving the detriment. Very good. Even if I suspect there was electronic assistance. Okay. You guys were here today because we had this opinion called Zoe T, and it kind of raised the issue of, you know, what is happening at the 2-2 hearings. And Zoe T was an amazing case. It was interesting literally from day one. And it's the kind of case that, you know, I want to be honest about this, it comes around maybe 1 in 100 cases. But when it comes around, you don't want to miss it. You don't want to fall into the trap that we all at our firm almost fell into, and we kind of did fall into it in ways. But ultimately, we followed the law and not, you know, our personal opinions, and we got this amazing opinion from the appellate court. So first, I would like to kind of take you through the beginning of the case, and it started with Joe Mellis, who was the attorney at the detention hearing, and I'd like him to
Yeah, we can hear you.
I need you to mute.
And we would like Joe Mellis to start. He'll just give you a couple of words about the very beginning of the case, and then Devin Taylor took it over from Joe, and she'll give you a few words, and then I'll come in and tell you. I only came in for the one hearing. So go ahead, Joe.
You want me to come up there?
Sure.
Good afternoon. So this case, we picked up the client and on a detention, and the first thing he said was, "I'm getting private counsel." So I had read the detention, and there were a lot of allegations. There was a dirty house. There was the mother had killed herself in the bathtub while the kids were in the house. She shot herself with a shotgun. There were drugs. The dad had like 12 allegations total against him, and it was I think I'd been here like not long enough to feel like, oh, I can deal with this, or this sucks, but I can handle it. It was more like, so what do I do? And then he comes to me, and he had a lot to say. He was a motor mouth, and he remained to be a motor mouth through the entirety of the case. But he finally said, well, I'm hiring private counsel. And I'm like, thank God, I'm not going to have to deal with this guy. Because immediately he was a pain in the ass. He's the kind of person who would ask you questions, and then he wouldn't stop talking so that you could answer the question. And he was really, I mean, he was just like that. I mean, he was relentlessly like that. So I was happy to be done with him, A, because I didn't feel experienced enough to deal with the case, and B, because he was a fucking pain in the ass. And so then the private counsel takes over. She asks me some questions. She clearly doesn't know what she's doing at all. I mean, like, at all. And I'm like, whatever. He was, while he was talking to me and saying all these things, he was also dropping, you know, he was like, oh yeah, I take care of pools for these big movie stars, and rah, 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 and I'm like, okay, guy. You know, but I was really glad to be rid of him. And then, at the 6-month hearing, he comes up to me. He's like, I fired my lawyer, and will you please help me out? And I'm like, well, I guess I have to, because I had formed a relationship with him before, and now he's here. And I look at the file, and of course the private attorney had made a horrible deal for him. She pled him out on basically every single allegation, didn't really change any of the language. There wasn't really evidence to support some of those allegations, and it was just a mess. It was a nightmare. And here it was in my lap. So I think that the reason that I'm here right now to tell you about this is because I was like, fuck you, dude. Fuck you. You had a chance with me. You decided to go with this person, and now you're there, and I don't like you, and you piss me off, and I really don't care about you. And this is for the people who are newer to this scene. Like, that is a really strong and powerful and profound feeling. And it cannot be a part of what you do here. And that was really the issue. It's like, okay, so I don't like you, I don't like what you did, I don't like the way you conduct yourself, I don't like the smell of you, I just don't like you. But I need to set that aside, because what is happening to this gentleman is not right. They didn't have evidence to do what they did, and they were already railroading him toward TPR of all 3 of the kids who were associated with him. They had placed the kids with a relative who was poisoning these children's minds against their dad. And in fact, ultimately, it was just the one child who was his bio child who ended up, or who it looks like is going to end up with him. But the other 2 kids were over, you know, they were pretty much gone and hated his guts. And this woman was just like, pop, 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 in their ears. So ultimately, though, we had a good contest on the 2-1E. He was in substantial compliance. He was doing everything. But he was also doing all kinds of bizarre things. Like, he would send these emails to the social worker and everybody else that whose email address he could find, and they would go on and on and on and on. I mean, they were 20-page emails. They were so long, and they were repetitive, and you're like, stop sending the emails. Stop talking. Don't talk. But he never would stop. And so that's about it. I'm just setting the table here. This guy was extraordinarily difficult. He went the wrong way from the beginning. He found himself in a horrible position. He was unable to stop himself from talking, stop himself from digging himself deeper and deeper and deeper and deeper into holes. And yet, according to the letter of the law, he was in substantial compliance. There was no real way that they could show that he posed a risk to these people, to these kids. And there was clearly coaching going on from the caregiver. And we did have a contest at the 2-1E. The judge decided against us. And one last thing was, the minors counsel in the case, ultimately, it's debatable whether or not she maybe should have declared a conflict, but she clearly, during the course of the case, became more and more and more biased against this guy, until it got to be where it was very clear that she was not, it didn't matter. His compliance with the law and his actions were not what mattered. What mattered most to this particular attorney was she hated his guts and she didn't think that he deserved his kids back under any circumstances at all. And that was a burden as well to overcome, you know, just in terms of dealing with that person on the case. Because you couldn't get, while normally in most cases with this person, pretty much all the rest of your cases you have with this person, that person was going to do the right thing. They were going to do their job properly. In this one particular case, this person could not keep their mind right. And all their emotions crept into their perception of what was going on legally and how she should proceed. So that's it. Is that good enough?
Thank you.
All right.
Devin?
Hey everyone, so I transfer courtrooms. Oftentimes we feel like that's a disservice to our clients because they don't know about it. You're not the client who they had in the beginning. That client was awesome, or that attorney was awesome, or that attorney sucked. So you start off like, uh-oh, what's going on here? The important thing that I tried to do was build rapport with this client, which was very difficult. I stepped in at a point where we were at the 2-1F that turned into a 2-2. So it was either you're going home or you're not going home at that point. And the client was extremely difficult. I always have concerns when you get emails that are not from your client, but like they're a family member, because there means there's some hand-holding going on there, and something else is just not right. So I would get random emails that said, visit with Zoe, October 10th, park, this time to this time. Call social worker, no answer. Drug tested, negative, this date. And I was like, oh, okay, but who is this man? I had yet to meet him, but I was getting all of these emails from his sister. So eventually the calls started to run in, and I was like, oh crap, like what is this case about? So because we were on the case the entire time, I had to learn this file. I had to learn it from the beginning to the end. Luckily I had a dark date, I requested the file, made copies. Everything that Dad said, although he said a lot, was true. He said, Devin, I did an upfront assessment. They said I had PTSD. Why are they saying all these other issues with me? I drug tested for the department this time. And again, I'll continue to do so. It was just a dirty home and failure to protect. And I'm like, yeah, you're right. But I had to let him know that I knew his case, because that was going to be another barrier for us to work together and get along. The benefit of me coming onto that case is I had a fresh set of eyes, so I didn't know about all the past feelings about my client, what other attorneys felt about him, although I had my own personal concerns. I didn't have the length of time with this case, so it did help me really look into the law and not really take him as his personality and who he was. He did have long emails. I got to the point where I told him, just email me, like don't email anyone else. I would have to print them out so I can actually understand where the question was, what was he saying. I would put like, what? Question mark, like what does this mean? But besides all that, this was a man who did everything that the court wanted him to do and had monitored visits for over a year. And what I found was that the allegations that were sustained were very bare bone allegations, and the issue was that he was portraying himself as crazy. You know, he would do bizarre things and the department would blow it out of proportion, like Dad was gushing blood at the visit and it hurt the child. Well, this man wants his visit. That's his daughter. That's what he looks forward to every week. So yes, he might have cut his ankle and bled a little bit, not gushing, but he was like, damn it, I'm getting to that visit, I don't care. Because that was his child. She lost her mother. That was the only parent that she had. Title 20s, read through those, they were glowing. We could make, use the record to suggest that this man played Play-Doh with his daughter, and he made little tacos. Come on now, who don't want to make little tacos with Play-Doh? Got the lettuce and the meat and everything. I was like, I want to make Play-Doh tacos. So he was awesome dad. He was very good with her. They would do like fairy tale tea time on these monitored visitations. So I had to learn the case. So I do, understand that it's difficult when another attorney takes over and then you don't know what had happened. What was difficult about this case is because he was a difficult client, he talked to a lot of people. So he had Joe, he had Marlene. So I wasn't always clear as what was said to him. So a well-documented file had to be really good in our case. So I found out eventually in reading the file, we had thought about filing 388s multiple times. However, we didn't want the burden to shift on us because there was always something in the last minute that was like, oh, this is not savory. Something's wrong about this dude. Something mental health, some poor visit. So we never got to that point. But I think it kind of worked to our advantage in a sense, including the passage of time, because now they had to focus on the law and what was required of them at the 2-2.
Well, they were supposed to.
They were supposed to, but yeah, we know that did not happen. I think for me, the biggest part was listening to my client. Oftentimes I understand there are things that they neglect to tell you, but everything that this man had a concern about was right, and he was well within his right to know what his educational rights were to his child. Had they ever been limited? If she was in therapy, was there a diagnosis? Why hadn't his visits been liberalized? And unfortunately, I didn't have the answer to those questions, but what the social worker had said, you know, their concerns. And he would make very valid points. At one point, there was a suggestion that the child needed stability and continuity, and they suggested changing monitors for the visit. So Dad was like, how is that stability and continuity? They're changing her monitor. You right, document that. There was a lot of things that he said that I was like, I get it. So you also have to listen to your client and understand where they're coming from and humanize them. I mean, I know we have a lot of reports and paperwork to read, but this was a case that this man should have had his child. You also need to trust your gut. It became difficult for me because we were at the wire, but just something wasn't right about this case. Because at one point, Dad was supposed to have unmonitored visitation, and he needed, I believe, 6 clean tests, and I believe at the 5th one, it was dirty, so he didn't get that. But the department never liberalized, and he attested for over a year, negative. So it was just a lot of issues in this case that were hard to address, but at the same time, our client helped tell a story, and I think Dennis did a good job in eliciting great testimony regarding what he's done in his treatment and things like that. But it was difficult, and I had to hand it over because that client was difficult, and I couldn't. New caseload, everything like that. So yeah.
So let me just to give you a background, and thanks, Devin. That was amazing. And the reason why I wanted them to talk is because what I did at the actual 2-2 contest would not have been possible had I not been handed a great file. And you know, both of these lawyers did such a great job of documenting. And then it just so happened, as luck would have it, that I was training a new attorney, Ms. Bashaw at the time. And so then Ms. Bashaw was able to go through the file, and she did a timeline, which I think is really critical. And what I'm going to try to focus on in this is how you do this. You know, what you do when you've got that set of facts that you think might be your 1 in 100 chances to get the right decision for your clients, and if not, get the judge overturned. I knew from day one that it was going to be a tough road, and that the judge was against my client, that minors counsel was against my client, that minors counsel didn't want to be Smealed, so she was getting her supervisor in to try the case. And so, you know, everybody was just, you know, they were all bent on, you know, kind of with kind of a personal bent. They were all bent on keeping this little girl away from her daddy. And so one of the things that I strongly encourage everyone to do is a timeline. You know, it's not big, it's just 1.5 page timeline, and they are invaluable because when your clients are telling you stories, they're going to get dates and years wrong, and you want to be able to focus them. And when you can do that, they know that you know their case. And that's the kind of confidence you have to instill in your client, because I had to change him completely from the man who had had conversations with these social workers and the man who was writing these 10-page single-spaced small font emails into someone that could actually tell his story in a meaningful way on the witness stand. And so I had to tell him things like, you know, Robert, you have to stop. You have to stop. Tell me what your 3 biggest concerns are. Send me an email with your 3 biggest concerns in 3 sentences. I actually had to, in ways train him how to talk, in a convincing way that wouldn't make people think he was crazy. And when Devin used the word crazy, when Joe used the word crazy, we're using the word crazy in the way we would use it for each other. The man, so let me just read you this. This is important that you understand that this isn't just someone we're talking about. So in closing this run-on of a post that I'm so familiar with, I just wanted to share how hard it is to start to pull the memories off of the wall of this bathroom, which has become a shrine to her. To Michelle, that was the mother. This bathroom already held a lot of significant energy, memories, and weight for us, and was almost always the place of heavy discussions and happy discussions, and so on. Michelle had lovingly hung a sign next to the toilet that said letters that read, "Michelle loves Robert forever." When I got there to her side and found her there struggling with life, she had a pink paint pen in her hand that she had been writing on the wall with. She had also written all over this little chair that was in there so she could sit and talk to me. Yes, even when I tried to use the bathroom, I would plead with her to go away and give me some privacy. She would insist on staying there and say that she didn't find anything about me to be gross and just always wanted to be as close to me as possible. She was truly my biggest fan ever, and I was hers, and we were truly inseparable, as was written on the wall. The last thing she did in life before she chose to end it was to write 2 little messages next to where she sat on the bathroom floor. One said, "Loving Mikey, Shelley, Zoe." The other, the most heartbreaking message I will surely ever receive, she drew a heart and wrote in the middle of it, "I love you, Robert." She then apparently laid her head against the heart and pulled the trigger of a gun nobody knew she had and fired that one fatal shot, the first time she had ever held a gun, according to what she had long told me, and her fear and hatred of guns, passing through her temple and through the center of the heart she had just drawn, then slid to the floor where she was when I got there. I mean, this is a real person. Okay, I didn't think I was going to get verklempt myself. This is a real person who went through a real thing, and yeah, you can write that narrative knowing everything that you know as dependency lawyers, and you can say, wow, what a fucked up relationship, and wow, what amazing codependence. You can say a lot of things about that, but it's sad. And it was an event, and this man needed, a lot of counseling, and he had a lot going on. Ms. Bashaw then did an outline, and it's real simple the way you do these, because I find that the hardest thing to do is start. And I learned this lesson actually from Candace Roshan, who's supervisor at Ladle 5. And she just would always do it this way. I would walk by her desk late at night, and I would just see her doing this. I'm sure it wasn't every case, but it seemed like it. It seemed like she was doing it at least once every day. And she would put the name of the case on top. She would put, what she was doing, whether it was a direct examination of the parent or cross-examination. She would always write goal of case. Father wants Zoe returned. She would write goal of witness. In other words, why was she putting that witness on the stand? And Ms. Bashaw wrote, explain father's substantial progress in problem areas and continued improvement in therapy, critically examine 730 and question report's conclusion about Mr. Truxell's capacity to parent. And then she went on to the categories of questions and kind of the outline. And then, of course, you can see that when I actually did the direct examination, I had a lot to add to that. And it's important when you do prepare these written examinations that you listen to the answers. So many times I see our lawyers, they've got their prepared list of questions and they're just going down it, and then suddenly, the person testifies, yes, that happened right after I put away the machete, and nobody ever follows up on the machete. So you always want to make sure that you're listening and you follow up on whatever comes up that is new. I went into this armed with primarily one case, and that case was David B. And you have a copy of David B. And David B., I know most people's favorite case is JN, but, it's a great case, not taking anything away from JN, but David B. is my personal favorite. And what happened in David B. is exactly the situation. It was a 2-2. The court found that the father still posed a risk to his daughter and failed to return and terminated FR and set a 2-6 date, and the court said no. And my favorite language is contained, I think it's on page 17, which brings us to the crux of this case. Actually, that isn't it. Where is it? Here it is. We do not get ideal parents in the dependency system. But the fact of the matter is that we do not get ideal parents anywhere. Even in Ozzie and Harriet, we're not really Ozzie and Harriet. Ideal parents are a rare, if not imaginary, breed. Some of us get luckier than others when it comes to parents, and most who work in this system are able to look back and realize how fortunate they were. But the state of California is not in the business of evaluating parents and redistributing their offspring based upon perceived merit. I don't just want to cheer the appellate court every time you hear that. It's just wonderful.
Where are you reading from?
David B.
No, what page?
14, I believe, out of 21. Yeah. But I have a different copy than you guys do. So it's under Roman numeral 2. It's the third paragraph when you get to Roman numeral 2.
Yeah.
Okay. The parents who come through the dependency system are more in need of help than most. If we are lucky, they are parents who can learn to overcome the problem which landed their children in the system, and who can demonstrate the dedication and ability to provide for their children's need in an appropriate manner. They will not turn into superstars, and they will not win the lottery and move into a beachfront condo 2 blocks from a perfect school. So that's what I went into looking at this case with. I believed I had a chance of turning this case into David B., and this is the way I do it. Everybody does it different. The way I do it is I try to imagine the best scenario. I try to find a case that I believe, got the result I wanted, and I try to make my case look like that. And there's really only one way to do that, and it's hard work. And when you're doing a contested 2-2 like this, you end up with a book like this. And this is why they're laughing over there, because they know this is yet again Candace Roshan, and something that she almost always does when she's got a really serious case. What? Okay, all right. So doing a trial book is really important. First of all, there's a little bit of psychology to this, and when you walk in there with a trial book, whatever, it doesn't have to be complicated. You see, I've just got a few Post-its as tabs, but I've got all the appropriate stuff in here, all the things that I know I'm going to need, all the stuff right there. So I'm not constantly thumbing through these files that are kind of difficult to deal with their 2-hole punches at the top. So do a trial book. It sends a message that you're serious to the court, to your colleagues, that I got this. You're up against it in this one. And the problem is that in this case we had a USC 730 evaluation. We thought that it was pretty clear that Dad had done everything. We thought it was pretty clear that Dad didn't have any, heinous illnesses or mental health issues that would keep him from parenting his daughter. So we agreed to the 730. And it came back, and I'm just going to read you one paragraph from it.
Who was it?
It was Keck Clinic, and so you get who you get there. This was Lorraine E. Quadra, C-U-A-D-R-A, and Adam Weissman. I would never agree to them, but when you send it to USC Keck, who I love, you can't tell them who you don't want. At least I don't think you can. Somebody might want to try that. Quadra and Weissman. Despite the lack, and it's clear that these people know nothing about dependency court. Despite the lack of a serious mental illness, the available information suggests several areas of concern with regard to Mr. Truxell's mental health, particularly as it affects his ability to parent the minor. Mr. Truxell has difficulty staying focused, lacks organizational skills, and has limited coping skills. He appears to be easily overwhelmed, and in times of stress, he is likely prone to serious emotional distress that may negatively affect his decision-making. Interpersonal difficulties seem to be particularly a strong trigger for him, like it's not for all of us. He presents as particularly reactive to negative evaluations of his character and parenting abilities, which may contribute to sometimes guarded or defensive reactions. In addition, while it is understandable that Mr. Truxell is grieving the loss of Ms. Garcia, statements he made during the clinical interview suggest that he may be inclined to not move forward in the healing process. In addition, DCFS has raised concerns that Mr. Truxell has continued to engage in substance abuse. Despite Mr. Truxell having completed court-ordered substance use treatments, some of his statements suggest he continues to minimize and rationalize his cannabis use history. That was the paragraph that, the department relied on, and the court relied on, and the court tried to lead me down the path of making the case about this 730. And I thought I really did. I can tell you now the truth. I thought I was making a mistake. I went back and forth about subpoenaing these people and cross-examining them. And I even got a continuance so that I could do that. And then I just felt that that wasn't the right answer, that it was, that to make it all about a 2-hour evaluation with these people, instead of about the 75 hours of individual counseling he'd had, was a mistake. As I filed the appeal, what I was thinking is, oh, the appellate court is going to, make hay with me about not cross-examining the USC 730 writer. But as it turned out, that wasn't true. They didn't even mention the 730. They did mention my client's therapist, who wasn't USC Keck Clinic, who wasn't a licensed psychiatrist or a PhD, who was just an MFT counselor, but who came in and testified. And they did make a lot of that person, with 75 hours of counseling, could not, the only thing that she could talk about that my client needed to do was work on his time management skills. That it was annoying that he would be constantly late for appointments and constantly late for visits. And she recognized that that was causing him a problem in his, with DCFS, and so she correctly identified the problem. This is something important. When you've got these difficult clients that you really can't stand, you're likely to believe it when a therapist calls you up and says, after you've subpoenaed them, and they call you and they say, no, I'm not really going to help you. Never, ever fall for that. They are responding to your subpoena. They are not responding to a question because you haven't asked a question yet. So I said, well, wait a minute, maybe you're not, really tied in yet to what I need you for. And what I need you to say is, does he understand why he's here? Number one. Is he committed to changing and to growth? Oh my goodness, yeah, he's been coming to therapy every week for 2 years. Is he learning anything? Oh my goodness, yes, he's learning a lot. He's really, when he first came, his first sessions, he could only talk about Michelle. It was all about that. As you can imagine, it would be. But now he's really moved on. He talks about Zoe more. He focuses on Zoe more. He really gets what he needs to do to get her back. He is, he's made a lot of progress. He's really committed to making progress. And he applies what he learns, because he goes to visits with Zoe, he works things out, he does things differently, and comes back and he reports to us about what he's done. And I said, I hate to tell you this, but you're going to need to come in and testify. And she tried a couple of times after that to get out and say, I really don't get it, because if they ask me, about his time management, if they ask me about this, if they ask me about that, I'm going to have to tell the truth. And I said, yes, ma'am, you are. Please do that. So the maxim I go by, that my attorneys all know, is that I believe most witnesses will do much better on the witness stand than you think they will. This is really true when you're most questioning it. And your clients who really have something to say and really want their story to be heard, you need to create an opportunity for them to tell their story. And let them go on the witness stand. And I'm always very suspicious, because I've just really not experienced it in my life, that you put on the client and they just melt down on the witness stand. Although it has happened, and when it happens, it turns out to have a silver lining, because they melt down at the dispo hearing, for example, when they're new to the case, or at the 2-1E even, and then you bring them back to the 2-1F, and they have, because they had this experience, they saw in the judge's eyes that they did not help their case one bit, and they actually went off and they did their stuff, they did their work. And then they come back at the 2-1F, and the judge says something like, well, you know, ma'am, I remember how you testified at the adjudication, and I am so impressed with the progress you've made. And it will get them over even maybe a positive test. You know, it'll get them over that hump and get them some unmonitored visits just because the judge can see, oh my goodness, you know, you were a mess, and now you're doing much, much better. So, remember to listen to your client's story. Remember it's their story, not yours. And then rewrite it. Rewrite it using the best case you can find on point that you think has some similarities that turned out the way you want this case to turn out. Serve subpoenas. You know, be generous in the amount of subpoenas you serve. Don't say, oh, I haven't talked to that person yet. He might have something bad to say. Well, serve the subpoena, because most of these people are not going to call you. They're not going to return your calls, especially if they have something good to say, because they know if they call you and say something good, then you're going to want them to come in and testify, and they don't want to come in and testify. So we spend about Ladle spends about $40,000 a year on subpoenas. So ask yourself, how many of those were mine last year? And if you don't think that you're using Ken's money very wisely, then send some more subpoenas out. Talk to your witnesses. Family support. Wow. Be kind to the family. I know the instinct is I barely have time to talk to my own client. I don't have time to talk to these 8 other people that they brought with them. But family support is one of the best indicators of success. Family support sends subtle messages to the court. It sends not so subtle messages to the social worker, because the social worker is going to panic just a little bit if they have not mentioned any of this family in any of their reports, and dad comes to court with 8 family members in support of him. The social worker is going to pee just a little tiny bit in their pants when they realize that that's what the judge is going to see, and that you can put her on the witness stand and say, did you talk to this person who's present here in court today? Did you talk to that person who is present here in court today? So if we go to Zoe T, there's just a couple of things I want to mention and kind of explain. On page 9, the first full paragraph, the court's talking about how the trial court instructed father, and when she says instructed father, it was instructed me, that the department would marshal their evidence. And so that evidence needs to be rebutted. That's what I want you to focus on. And what he was doing was he was telling me, it was very clear to me, he was telling me that he wanted me to cross-examine USC Keck based on their 2-hour examination. And I really did, like I said before, because you can't underestimate this, I thought I had fucked up, pardon my language. I thought I had made a mistake, because he was so adamant that I should have done that. And, it was so harmful. It did, in another paragraph, say something about, well, Dad certainly wasn't going to physically abuse Zoe. There was no evidence of that. He did feel that the father would be emotionally abusive because of his shortcomings. So sometimes realize that the judge is not telling you what to do in your best interest. The judge is not telling you, and I believe the best in everybody. I like to walk through life thinking that everybody I come in contact with is always acting in my best interest. So trust me, this comes harder for me than for any of you. When a judge tells me something, I believe that they are, observing the highest standards of their robe, and they're just telling me something, for my own good, and something that will help my client. That's not always true, and that's a sad lesson to learn. Sometimes you just have to make your hard decision and do what you think is best, because remember, the judge hasn't seen your file. So yeah, the judge was leading me down a path there to basically make a big deal out of this, so that the appellate court would make a big deal out of it when I appealed. Because he had also said months before, I know that no matter who wins, this is going to be appealed. And we all go, yep, it sure is. And by the way, that's why before I went to trial, I talked to my boss, Marlene. I talked to Ms. Vappy, who had been our former writ attorney, and I had a good rapport with her, but so I asked her. I talked to our own writ attorney, who was at the time Jody Marksimer. See Jody sitting right there. It was Jody Marksimer, and he did, by the way, the first draft of this writ. Nicole did an amazing second draft of it as well. It was really, truly a firm effort. What was I saying?
Everybody's good. Judges are good.
Oh, right. So, yeah, and I was asking them all the same question. What do I need to do to properly set this up for appeal? You know, what ball should I make sure I don't drop? Give me advice, give me some input. And everyone just focus, keep it simple. You've got David B. You know that's what you need to make this case look like. Follow that, cite the hell out of it. The department is going to talk about Constance K., which is the department's case on this subject, and you are going to be able to distinguish that very easily. Constance K. was a horrible case. Sometimes we appeal cases we shouldn't appeal, and then we get bad cases. But don't worry about those. You're worrying about the cases like David B. and making your case look like those. Finally, you have to put on evidence. So the evidence comes in two forms. Everybody remembers this. There's written evidence and there's testimonial evidence. And that means you've got to bring people into court to talk, and you've got to introduce the documents. Department, you don't fall for the trick of thinking that the department enters all of the documents into evidence. If there's a report that doesn't help them, they can conveniently leave that off. So make sure that on your exhibit list, it does include the reports from the department that you're going to be relying on in your case, because that's part of your evidence, not just the department's evidence. Title 20s, make sure if you're going to refer to them that you've admitted them into evidence. So many times our appellate attorneys are looking at these records and they're seeing that argument was based on Title 20s that were never admitted into evidence. And that can be an unnecessary fatality in your case. Our case was pretty simple. I put on the minor, I put on the father, and I put on his therapist. And there's a lot of drama about the minor. The bottom line is, I don't know if Joe made it really clear to you, but she was placed with the sister of the dead woman. So the sister of the woman who had committed suicide in this horrible, horribly filthy house. She said on numerous occasions to our client, "You killed her." And that became a theme in the case. I don't know for sure if that's what influenced Minors Council and County Council to be so aggressive in this, but I'm sure that what the sister meant was, you killed her as surely as if you'd pulled the trigger. I think she might have even said it that way once. But the rest of the time she was just saying, "You killed her. You killed her." And it was just this unnecessary craziness in the case. Now, I also had some evidence behind the door that I did not think, because I didn't introduce it, I didn't think that the Court of Appeal would pay any attention to, because it wasn't really evidence. But I had served subpoenas, and additional subpoenas on the initial intake interview with him that he had said had gone really well. The Project Fatherhood counselor who had written a very short but very nice letter about him, but I needed some more details from him. And there was one other, can you remember who it was, Erica? There was one other subpoena that we had issued. None of these people were there in court. None of these people had come. I had proofs of service for all of them, but none of them had shown up. So I did tell the court that I had them, and that I would need bench warrants issued to actually get them there. And he wouldn't do that because he was going to do this hearing, this whole complete trial in one day, come hell or high water. All of these, by the way, are decisions that the appellate court chose to comment on. And it didn't go well for Dad. So like I said, the judge wanted me to focus on the USC Keck 730, and instead I decided to focus on the word prolix. Because when he said it, we were all, what? Prolix. And he wouldn't define it for us, like, telling us to go look it up if you don't know what, if if you don't have access to an advanced vocabulary. Go find your dictionary. So we all looked it up, and then he used it again. So he probably, the whole course of the case, only used it 3 or 4 times, but then I used it another 20 times. That record will find me always talking to the judge about how I know he's concerned about how prolix my client is. So I basically did the same thing, but turned it around. I decided to focus on the things that I knew would make the judge look ridiculous. And then the judge did me this amazing favor by writing out his opinion in a 21-page written opinion, which I call now 21 Ways to Get Reversed. And he was elitist, he was arrogant, he was very, very clearly talking about his life in his $3 million mansion with his 5 adopted children, and not talking about our kids and the families that we serve. And it's almost like the appellate court was lying in wait, that they were just waiting to see what kinds of things he was going to do, because they jumped on him. And as you see when you read this, it's one of the most fun cases you'll ever read. You really should take it and pour a glass of wine at home and sit in your comfiest chair and really revel in this case, because they just don't get much better than this. I mean, am I right, Danielle?
It's pretty good.
Yeah, it's fun. It's really fun. And so I want to close. Is it time to close? Oh, okay. Yeah, and that'll leave us some questions. I want to close with the last paragraph, but for the disposition of the case on page 16. And you really... So I thought I was going to be able to say you should add this to the things that you've memorized, like, 366.22a. But so definitely memorize that first, and then memorize this sentence, which is in all respects. The department. So they didn't just slap the hand of the department. They slapped the hand of minors' counsel and the court. So in all respects, the department, Zoe's counsel, and the court should proceed with due regard to the legislature's directive that the focus of this hearing shall be on the preservation of the family, as well as the safety, protection, and physical and emotional well-being of the child. And while this is an unpublished opinion, you can never say the words Zoe T on the record. Do not say the words Zoe T on the record. This is an unpublished opinion, although we have... Oh, did we hear it?
So it is gone up to the California Supreme Court. So the Court of Appeal has decided to remain, continue their position not to publish it. So now it's up on the California Supreme Court.
On just the decision of whether to publish or
Yes.
not, or did the department? Okay.
Just the decision to publish.
Okay, so we are still pursuing our efforts to publish it, but the appellate court has declined to publish it. So while you can't cite Zoe T, all of this language, all of this reasoning, all of the case law that is cited in Zoe T from David B. on, all of that you can use. Okay, anybody have any questions? Yes, please.
I don't think we often put children, at least I don't often put children on in a contested tutu. Can you talk a little bit about the questions you asked?
Sure. Well, what happened, it was amazing. There was a lot of stuff in the record about Zoe loving her dad and wanting to go home. And then, right before the tutu, there started being little things, little intimations coming in that, oh, maybe she didn't really, maybe she was upset that her daddy couldn't get along with her Aunt Tina, her Aunt, what was the woman's name?
Tia Aaron.
Oh, Tia Aaron, yeah. That his dad couldn't get along with Aunt Aaron. And, it's hard to get along with somebody who's accusing you of murdering the woman you love. And so, no, they were never going to get along. And also, Zoe would also say things like, they're hitting me. Daddy, Tia Aaron hits me. And Daddy, I can't tell you about Tia Aaron hitting me because she'll get mad at me and she'll hit me even more. These are things that are being said to the dad. And are they making it to the reports? No, that's not making it to the reports. So I felt, because of the circumstances of this case, that there was a lot that I needed to clarify. And so I asked her something pretty innocuous, was my first question. Like, probably, right now you're living with your Aunt Erin, is that correct? And she launched on a 2-minute, seriously, a 2-minute prepared statement about, yes, I don't want to go with my daddy right now because he has a lot of change work to do because he pushed my mommy down the stairs and that wasn't the right thing to do and he shouldn't be allowed to ever do that again. And I'm like looking at like the judge, did you see what I saw? And all of the other counsel, and then I was flabbergasted. So again, it's not always that the witness turns out to be so great. That is why you want them to testify. It's the truth is going to come out though. That's what happens when you put a witness on the stand. Most people, I believe, and again, I am who I am, I believe that most people, I'm like Anne Frank. Most people deep down inside are good. And I believe that most people put on the witness stand and swearing to tell the truth, the whole truth, and nothing but the truth will do just that, at least as they understand it. People people may believe things that aren't true. People may have convinced themselves of things that aren't true. But I do think that most people on the witness stand are going to try to tell the truth. So I always err on the side of putting those witnesses on. Marlene?
At whatever status review hearing you're at, where the department has recommended the termination of notification and you set it for a contest, before you start building your trial notebook and putting on your contest, how, in this case or in other cases, would you use Elizabeth R.?
Well, okay, so now everybody knows, all in unison, Elizabeth R. is a case that talks about the application of what code section? 352. And 352 is the code section that governs continuances, exactly. So I've given you Elizabeth R. because I want you to see it, I want you to understand, what happened in that case, because it is an important case, but you can't really cite Elizabeth R. to most other specific fact patterns. What you want to do is argue the reasoning of Elizabeth R. and to remind the judge that they can, at any stage of the proceedings, continue any hearing as long as it is in the best interest of the minor. Are we all clear on that? Yeah. So I had actually given this judge options in my case. I had, in closing argument, I read the writing on the wall. I knew what was going on. I could see the expressions on people's faces, and I had to sit there and subject myself to Brian Thompson's beautiful closing argument, where unfortunately he complimented my client a bit too much, I guess, to support his position in the appeal. But it was oratorically brilliant. He started by talking about the airplane analogy, that if you're flying on an airplane and there's a problem, the oxygen masks are all going to drop. And if you're sitting next to a child, you will be instructed to put your oxygen mask on first. Because if you don't take care of yourself first, you can't help the child if they want to struggle or argue with you about putting this mask on. So you always put on your mask first. So he opens with that. And then he blah, 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 goes on for like a 20-minute closing argument. And then he closes with, and so in conclusion, Your Honor, although the father has made a good attempt, I don't think he yet understands that he has to put his mask firmly on before he can take care of his child. And I was like, holy crap! I mean, that was beautiful. You had to admit, come on, it was nice. It was like the kind of thing that we would do in law school. So, what I proposed to the judge, Your Honor, under 352, you can continue this hearing. I understand that you have some concerns. So why don't you continue the 2-3 months, give Dad unmonitored overnights and weekends, make sure the department is putting him in charge of getting his daughter to school and to her therapy appointments, and when we come back in 2 or 3 months, you're going to know, is he able to do these things or is there an actual risk? Continue this and get the evidence you need. But whatever you do, you cannot terminate his family reunification services today because you don't have the evidence you need. Instead, you have virtually an identical case to David B. So while you're not going to be citing Elizabeth R., in many of these situations, you're going to be creative about what it is you can do to really resolve these concerns. How could the case change so that the judge would feel differently, so that minors counsel would feel differently, or just so you have an even stronger case? And give the judge the option, or ask outright for him to continue the matter.
Dennis, why wouldn't you cite Elizabeth R. along with everything else, showing that the court has that option?
Well, because I don't need to. Because, I mean, if the court is doubting that they can continue the hearing, then I would cite Elizabeth R. Your Honor, that matter is well settled in Elizabeth R. But the problem is the Elizabeth R. as a case is super fact specific. It's about, you would want to use this case if you've got a client who had spent, all but 5 months of her 18-month reunification period in a mental hospital, but despite that had constantly done amazing visitations with her child, and who had reports from her psychiatrist that she was off the charts in intelligence and in emotional intuition, and just needed a little more time in order to kind of get it all together. And then there was also an issue that was really important there about the department telling her she needed to leave her husband and make that Sophie's choice. It's your husband or your kids. And in Elizabeth R. talks about all of this, but Elizabeth R. was very fact specific. So you would only cite it if the court is saying, I don't think I can, I think I have to, it's a 2-2 hearing. This is final, this is the end of the road, that's what everybody says. There's only 2 choices I can make. I have to either return or I have to TFR. And I don't know that there are many judges in the building in 2017 who still believe that, but I know there are a couple. She thinks there's a lot. Okay. Any other questions? Really? Yes.
How do you handle the perfect full compliance cases, but then either like the kids are not ready, or like Devin was saying, they're crazy, but they're in full compliance?
Right. Well, that's this.
So
that is Zoe T.
But they're done.
Yeah. He had done everything, and he was still doing everything. He was still, and today, he is still going to his therapist every single week.
So, but your decision is to put on the client usually, or call the provider?
Oh yeah, I can envision a factual pattern where you wouldn't want to put your client on the stand, but at a 2-2, it's all about your client. It's the department is going to either show that there's something in the case plan you didn't do, like you haven't done enough individual counseling or something, and they're gonna actually raise that prima facie evidence that that the risk would continue, or that there is a risk, or they're going to be saying yes, the father did do all of his case plan, but he didn't change.
And just like a follow-up, I think really what I'm getting at is how do you explain it to your client?
Oh, very easy. I tell them on day 1. So remember, there's also this. All of these answers could have been, go back to detention and remember to do this. So most of you were at a detention training, but the detention hearing is the most important. And at detention, I tell every client, listen, here's the deal. You have to do these programs in order to get your kids back. Every day, there are parents who come here who have done all of their programs and have not gotten their kids back because they didn't really learn anything. They didn't learn anything, and they didn't apply what they learned. Also, there are parents who come here occasionally who have not done everything they needed to do, who have not done their whole case plan, but they get their kids back anyway because they have changed. They have learned what they needed to learn. Sure enough, they didn't finish the rehab that they were supposed to go to. They got kicked out because they made a choice to go on a date or something. But you know what? There's 18 months of clean tests. And they're going to their 12-step program, and their sponsor is coming in saying they're working the steps. So, you just have to tell them. You can do everything and not get your kids back. You can also not do everything and get your kids back. But what you have to do in either case is you have to change. You have to change from the person that caused risk to your children into a person that the judge can feel comfortable does not pose a substantial risk. Any other questions?
Sir,
Yes.
question. Whether or not a client has actually changed, that's the court making inferences, correct? Which can actually be relied upon.
Well, no, I mean, I think that it's, so I have an acronym, all my people know, it's called AUCLA. I wish it were AUSC, but it isn't, it's AUCLA. And the first A is acknowledge. They have to acknowledge why the judge believed they posed a risk. Number two, they have to understand why that behavior that they did posed a risk. Number three, C, they have to commit to changing, to learning what they need to do to get rid of that risk. Number four, they have to learn. They have to, you commit by going to a program, but then in that program you actually have to learn something. And then the final A is you have to apply what you learned. So if you put a witness up on the stand, you put a father up on the stand and they go through AUCLA, then that's the evidence that the judge is going to use. The judge isn't going to have to intuit it or infer it. There's the evidence. And the department will then have to come up with some way to show that that's all not true. It's not all as rosy a picture as you paint it. Anyone else? No? Awesome. Was it? Did we do that? Yeah.